How you doing? This is Raquel. Don't forget to like, share, subscribe. If this is a fun and helped you, don't forget to comment. Okay, so we want to pick up from the elective share, and remember we did. I talked about when someone leaves a will and intentionally disinherit his or her spouse. That spouse, at least in New York, I'm a New York attorney, so please make sure that you seek your attorney in the state where you reside because the law varies from jurisdiction to jurisdiction. So, I mean, generally, some information is the same, but just make sure, okay, that you seek an attorney. Nevertheless, so when a person passes away and the surviving spouse can now cannot file for an elective share, right? So that elective share is not automatic. So after the court has probated to will and grant the letters of testamentary to the executor of the estate, the executor is the person that the decedent named in the will to carry out his or her intent. So after the probated process, which is a while, which is one of the reasons why many folks prefer trust over will, but I'll get into that when I start trust. But let's say the year or 2 years has now come to an end and you have paid the lawyer, what you to pay them, etc. The surviving spouse have 6 months after the court has probated the will and grant the letters of testamentary, or 2 years after the decedent's death. Sometimes the court will extend the time after 6 months, right? It varies, but it's not automatic. However, the estate can fight back under certain situations. That's a great thing about the law. So even after practicing for 23 years, I never get bored because it just remains really exciting because clearly I don't have a life. This is what excites me. Anyways, so if there was a prenup or a postnup, a prenup means a contract before marriage where the spouse waives his or her right to the estate, or a postnup where you waive your right to the estate after you are married, then you have no right to the estate, right? If the person passes away before filing, sorry boo, the elective share goes with that person. But if the person passes away after filing, then they still get it and it can go to the estate. So another exception, if the estate say, listen, Your Honor, this surviving spouse abandoned the decedent, and it's not automatic, they have to prove abandonment under that particular jurisdiction. So those are ways in which the estate can fight back against the surviving spouse. Okay, now the assets that the spouse can go over in this elective share are not just those that were in the will. They have what we call testamentary substitute. Now these are assets that are not in the will, right, or trust. So in this case the will, right. So for example, if the decedent had a bank account, you're going after that joker. Even if it was a joint bank account, you're going after that. If another person actually contributed, then those part wouldn't count. If there are annuities, if there are pension plans, those are all up for grab. The only thing that doesn't count is insurance, right? Life insurance don't count. Now it's very interesting because, as we mentioned, the estate is, the surviving spouse can get 50 grand or 1/3, whichever is greater. Do not confuse that with somebody who died intestate. If a decedent died without a will or trust intestate, then the surviving spouse, they don't have to prove that they have not abandoned. It doesn't matter. They can they're automatically, it's an automatic right? They're getting the first 50 and half if they had children. If there's no children, the spouse is getting everything. So that's a situation of if there is no will, if there's no choice, if the person died intestate. All right, so sometimes I have clients like, Raquel, I really want to do some estate planning. I don't have enough assets to have a will or trust. But estate planning can be as simple as you have anything in a bank account, you get a trust upon death form, and you just put your beneficiary. I want X% to go to Jill, Jack, Joe, whoever, right? It's sometimes it's as simple as that. It doesn't have to be that you have all these mansions and cars and planes and all this stuff, right? Let's say you only have one house and you don't want to go through the process of have your loved one go through the process of a will or trust. You just want them to have the house. Then there's a way that you can do a deed transfer, right? You can do a deed transfer where you say, you know, I want to live in the house for my life, and then after my life, the remainder go to X. That's a life estate deed, right? And all of this will cost you less than $1,000. So there are ways in which you can have your estate planning done without breaking your bank account, right? You also have power of attorney. Power of attorney is, I want this person to make decisions while I am alive. But please be careful. There is durable power of attorney and there is general power of attorney. You want to make sure that you have durable, which means this power of attorney continues even after I am deemed mentally incapacitated. But you want to make sure that you are certain, if you want your agent, power of attorney agent, to begin being your agent once you're mentally incapacitated, and you should put the name power of attorney once a physician has deemed me in writing to be mentally incapacitated. That's when it will trigger my agent to act. Or if not, you don't put that, that person can be your agent right now. So please be careful, because it can be a very dangerous form, because you're giving them the power to do everything, but you can also specify what it is that they have the power to do. Like I just had a closing, and my client was in Georgia and she couldn't make it. And so you can say, I want you to be the power of attorney for this specific transaction, right, in New York or wherever you are. And okay, so that's one thing. You can also have the living will. The living will is, this is while I'm alive, when I'm in the hospital, if I'm comatose, you know, do I want to be artificially fed? If I am deemed terminal but I'm in pain, do I want them to give me medication to ease my pain, though it hasten my death? Do I want to donate my organs? Do I want to be resuscitated or not? If I donate my organs, do I want it to be for research? Do I want it to be, you know, given for someone else? This is called a living will, right? So these are things you can do that doesn't require giving away house, car, plane, land, right? It's just little things that will make the life of those who you left behind so much easier. I mean, it's drama enough to mourn as it is, right? But just make it a little bit easier on your loved ones. And then you also don't have to spend a, you know, arm and a leg trying to put your affairs in order. There are ways that attorneys, you know, can work with you, whether it's payment plan or what have you. But I always say to my client, whatever it is that you got to pay, is that worth the peace that your family is going to have? And if you don't do it, is it worth the wealth that your family can lose after you transition if your affairs is not in order, right? And we can, you know, we can talk more about that. But I hope this helps someone. And, you know, during COVID, they said only 1% have their life estate in order. Many people did not have a living will. Doctors didn't know what to do. Do we resuscitate? Do we not resuscitate? Do we pull the plug? Do we not pull the plug? So have the conversation with your family, folks. Okay, that's a form of love. It's a form of taking care of yourself. Estate planning is just as important as family planning. Okay, take care of yourselves, your family, each other. Don't forget to subscribe, share, like, all that good stuff. As they say in Jamaica, talk to you later. Yeah, ciao, ciao.